Welcome, everyone. Thank you for joining us today. For those of you who don't know me, I know we've got a lot of new folks on the phone today. I'm Hannah Shea with World Law Group, and I work with all of our practice and industry groups. We did kick off our Beyond Borders program this week, which is our 4-week program, virtual program for young lawyers. And we have a number of our young lawyers on the call today, so welcome. We have asked them to identify that they're a young lawyer, part of the Beyond Borders program, by adding a BB in front of their names. So if you are a young lawyer and you haven't done that, and could please do so. And also, while you're at it, we've asked that in the email reminder that you rename yourself to include your firm so that we know where you are from. With that, I'm going to go ahead and hand it over to our co-chairs. I'll quickly introduce Ted Agostinos is one of the group's co-chairs from Lochlord in the US. And then our other co-chair is Christian Runti at CMS Germany, who will be guiding us through today's calls. So with that, I'm going to hand it over to Christian.
Thank you, Hannah, and thank you all for joining this call. It's great to have so many on the call, and just for the record, I also at least feel young, so I don't know whether you need to specifically identify yourself as young, but there seems to be some rule to it. So we have these data protection calls at least twice a year, and we focus on a specific region each time we have that call for practical reasons, and so that we can do a more in-depth view of local developments and legislation. And so this time it's the EMEA call, and that means that it will mainly focus on Europe, but it should also focus more on the rest of the EMEA region. So we have a number of speakers and topics that we want to discuss today, but if you have questions or your own experiences with data protection in this region, it would be great to hear from you as well, and there will be enough time so that we can discuss local developments in your country as well, if you want to share something or ask something. So I want to introduce the three speakers that we have today, although everything should be a discussion. We have Dirk from Switzerland, who is a tech and data protection lawyer and heads the group over there. And you can maybe briefly introduce yourself, and who will talk about the new Swiss data protection law, which is, as you all know, not part of the European Union, and therefore it's not GDPR, but it is still a kind of GDPR topic, at least in my view, because it is a new law in the light of and surrounded by GDPR, but we will hear about that in a minute. Then we have Christoph from Germany talking about a topic which I think, Ted, you originally brought up during one of our discussions, and that is that GDPR allows for access requests from individuals, from data subjects, and used to be a data protection topic, and it still is, of course, but it tends to be weaponized in employment relationships as well, and so it is an important topic with some practical issues around it. And then we have Lisa, also from Germany, will just kick off the discussion around GDPR and the experiences. Lisa just recently rejoined our team. She is a German data protection lawyer, but moved to Chile for the past 3 or 4 years, and so has this perspective on inside, outside the GDPR. And that's the overall program that we're looking at. But again, if there are any questions or anything else, there should be an interactive discussion. But having said that, I'll hand it over to you, Dirk.
Thank you. Thank you everyone for having me. My name is Dirk. I'm a partner at CMS Switzerland, and I'm in charge of the IPIT department. And of course, we also deal a lot with data privacy matters, especially now in Switzerland, because as you may have heard, our data protection law has been comprehensively revised, and it will come into force on September 1st this year. So you can imagine how nervous clients are at the moment, and some of them will be nervous after 1st September 2023 when they realize that they haven't done anything, but this is part of the cycle of lawyers' work. We are always benefiting a little bit from new legislation. Now, we have a short time frame. I pre-discussed this a little bit with Christian, and so we want to make this a bit informal and simple. Maybe in a 10 rounds presentation that I will highlight you the 5 most important bullet points of what has changed in Switzerland, and to which regard we have tried to get closer to the GDPR because we were always a bit distinct, and to which regard we have maintained our Swiss particularities because we haven't always been in line with EU legislation. So Switzerland has tried to build a compromise in their new law. So, maybe I'm not going to highlight too much in detail things that are just like in the GDPR because you already know that. So I'm probably going to refer to that in a more generic manner, but I'm going to point out the things that are different because that's important for you to know. And if you have questions, then of course, feel free to shout. But I will try to keep this relatively short in the sense of an overview. First of all, the 1st September 2023 is when this law comes into effect. There is no grace period. That's one question many people ask. It starts. The gun is loaded. The second thing, probably the most important for you, is the question many people ask is, what about sanctions? Are you guys following the same approach as in the EU with these draconian sanctions? Do we need to be afraid? Was this a question? I'm sorry. Oh, that was just back noise, sorry. Okay. The answer to the question is yes. We will introduce sanctions, but there is a distinct difference to the EU. In the European Union, the sanctions are administrative sanctions. So it means that the companies dealing with data are sanctioned if they commit some wrongdoings. In Switzerland, the sanctions that will be introduced are criminal sanctions. And criminal sanctions can only be imposed upon individuals. So the people that need to be afraid are not really the companies or the entities, but are the people in charge in a company, the people of the management, especially the people in charge of compliance matters and the DPO, etc., and so forth. Those are the people that can be sanctioned with fines up to 250,000 Swiss francs per infringing violation. This is very controversial. There are people in Switzerland who say this is completely stupid because it will lead to overcautious legal advice because no one wants to burn its fingers. This should be imposed upon the companies and not upon the individuals, but that's just the way it is. We will see as from September on how this will work, how much it will be used, and also to which extent, because I don't know, a lot of private individuals who can pay $250,000 just like that because they omitted to sign a data transfer agreement or something like that. So yeah, we will see how reasonable the prosecutors will be in this regard. So one thing that has always been distinct in Switzerland and which makes us different to the EU, I think, is the basic way of thinking about data privacy. In the EU, there is this basic understanding that any data processing activity is in essence forbidden. unless you can justify it by consent or by a contract or by overriding interests or that legitimate interests. This is something you often hear if you read commentaries of the GDPR. In Switzerland, the basic approach is the opposite. The principle of Swiss data privacy law is processing activities are permitted as long as you comply with the principles in the law, which is transparency, of course, which is proportionality of processing and purpose limitation, data security, and all the cross-border data exchange rules and data processing rules. But as a basic understanding, as long as you comply with these principles, you don't need a justification, a consent, or a contract necessarily. So this is a basic difference in the way we examine data privacy, because only if we find that there is a violation or that the principles are not met or likely not met, then we have to start examining this layer of justifications, consent, or contract, but otherwise we are on the safe side. And we have maintained this principle in the new law. So this will not change, even though we have tried to get a little bit closer to the GDPR, but we will maintain that as a principle. Now, to summarize in 5 bullet points, what have we copied from the GDPR, or what have we introduced? Maybe 5 points just summarized in advance that you hear them. We have more information obligations than we had earlier, very much in line with GDPR. We have more documentation obligations than we had earlier. Speaking of records of processing activities, we have more governance rules similar to the GDPR. We have introduced similar rules on cross-border data transfers and data processing with third parties. And we have increased data security obligations, very similar to under the GDPR. And in the following, I would just like... Hello.
Sorry, I think somebody went off mute. I muted them.
All good. That was just to say hello. Nice to meet you. So let me just go through these 5 points and briefly summarize what they're about, and then show you where we are different or distinct from the EU, because we're still a little bit less strict, a little bit less onerous. The information obligations. There is an explicit duty as from now on to have data privacy policies in place. This is explicitly provided in the law. In the past, this was not explicitly provided. We just had the principle of so-called transparency in the law, and this is why everyone had data privacy policies in place. But now it is explicitly written, and it is also sanctioned if you don't have it in place. In particular, we have also taken the same principles as in the EU on automated data processing, for which leads to individual decision makings. We have the same rule that if you use automated processing in order to reach a decision for a client, for example, the decision to grant someone a loan or not grant someone a loan, then you have to make this transparent, and you have to give the data subject an opportunity to ask for a human assessment instead of a purely technical assessment. All of that is more or less the same as in the GDPR. Maybe one thing to highlight where we are different and exceptional, as an exception, where we are stricter than the GDPR, our information duties also extend to the location of data. So if you write a privacy policy in Switzerland, you must also write where data will be located. To my knowledge, I mean, Christian, you can correct me, this is not explicitly required, I think, under the GDPR. If you comply with the data transfer rules, and you can say, if we ever send your data to an unsafe country, we will take the necessary measures. But in Switzerland, you really need to write your data is basically stored here in these countries. or at least a specific region, you need to write that. This is, I think, one aspect where we differ a little bit from the GDPR and have slightly more strict approach. Now, the second bullet point, the documentation obligations, we have introduced more or less the same as you guys in the EU. We need records of processing activities. It's a cumbersome process to produce that for clients. We have exceptions from this rule. If your company has less than 250 employees and you have no large-scale data processing activities with high risks, then you are exempted from that rule, but otherwise you will have to do this. The important thing to know is that this is not sanctioned in Switzerland with criminal sanctions. So we've taken the same requirement as in the GDPR, but we have not made it subject to sanctions. Then the third bullet point, the extended governance rules. All of you guys have heard of data privacy impact assessment, or DPIAs. We will introduce more or less the same concept in Switzerland, just like in the EU. I mean, for those of you who are not familiar with this concept, this is essentially a self-assessment of your data privacy activities beforehand. And if you come to the conclusion that there are high risks at stake, then you have to submit this to the regulator in Switzerland and consult him to find an appropriate solution. The distinct difference in Switzerland is that you really need a high risk in order to submit it to the regulator and not just any type of risks. And you can omit that if you have an own data privacy officer in your company, because then, you know, the law kind of assumes that there is someone within the company who can make this assessment instead of the regulator from the external side. We will also introduce data breach notifications as you have it in the EU. We have not introduced it so far in our law. Maybe two differences. I think in the EU, the rule is that you must notify data breaches in 72 hours, if I'm not mistaken. In Switzerland, the law says as soon as possible. Nobody really knows what that means. But what we have heard from the regulator in unofficial calls is that he will probably also look at these 72-hour time frame as a kind of standard. So there's no need to relax in Switzerland and to wait too long. We should probably be somewhere in this line. And the second difference is that we only need to notify if there is a high risk involved. To my knowledge, in the EU, it's not necessarily a high risk. I think it can be any type of risk or a lower level of risk. Switzerland has increased the threshold a little bit. So there's room for data breaches if we come to the conclusion that it's a low risk, for example, because very few people are affected. Let's say, you know, 2 clients of a company which has millions of clients, and no sensitive data is at stake. Then we might come to a reasoning that the notification can be omitted. The fourth point, what about sharing data with third parties, with processors, and what about sending it into other countries? I think it's fair to say that we have introduced more or less the same regime as in the EU. If you outsource data to an outside processor, you need to have some kind of agreement in place, a data processing agreement. We don't have as many mandatory content as you have in the EU. I think there's a long list in 28 GDPR what needs to be in this data processing agreement. In Switzerland, the only mandatory content is that subcontractors must be approved, but the rest is not really provided in the law. But let me say that this is all very theoretical because the DPAs are more or less an industry standard in Switzerland. We have these agreements in place since years, just like in the EU, but the statutory provisions are a little bit less comprehensive. And The same thing with transferring data in unsafe countries, like, let's say, for example, the US or India, or countries which don't have a data privacy standards that we consider adequate or equivalent. We have the same measures actually provided as in the EU, the data transfer agreements, which we recommend. And actually, our regulator is even a fan of the documents of the EU. So he has publicly said that we should use the EU standard contractual clauses in their latest version with these 4 different modules. So we are working with them as well in Switzerland. This, by the way, is a sanctioned area of law. If you omit these contracts and don't have them in place, sanctions can be triggered. And then finally, the 5th bullet point, we have increased data security obligations. You all are familiar with the word privacy by design and privacy by default. This has been introduced in the EU, I think 4 years ago, when the GDPR was enacted. I mean, privacy by design in essence means you need to plan data privacy beforehand. You need to make sure that your procedures are in line and compliant before you start, and not just react upon notifications of violations. We are of the view that this already applies under our law today, even though it's not explicitly written, but this is our understanding of the law. The only difference is that now it will be explicitly mentioned in the statute as a principle, just like in the EU. And the same is privacy by default. You need to have customer-friendly provisions, default provisions, which are provided without any input from the side of the customer. Now, in terms of the sanctions, a lot of people ask, is this sanctioned? And the answer is kind of, there's a tweak in the answer. If you have a lack of data security measures in your company because your IT systems are not adequately secured against unauthorized access, yes, this can be sanctioned. But the principles alone, data privacy by design and privacy by default, are not going to be subject to sanctions directly. I mean, unless a violation is attributable to a data security problem, a technical problem, and this has caused the violation of privacy by design and privacy by default, then yes, it can be sanctioned, but it's kind of an indirect trigger or application of sanctions. So this is, hello, Sherry, welcome. This is roughly summarized what we have introduced in Switzerland. Of course, the reality of the law is much more detailed. If you are interested in that, feel free to write me an email. We can send you a brochure of about 20 pages where we really comprehensively summarize all of the changes coming ahead for Swiss companies or companies with a Swiss affiliate. And if you have questions, please feel free. I'm here to answer your questions.
Thank you very much, Dirk. I mean, we may need to shift questions to the end, but there's one question I have, and it may be controversial, but if I'm an international company and I have, I want to roll out my services or have offices all over Europe, including Switzerland, I already spent a lot of money for complying with GDPR. Do I need to spend any more? Or is it a safe risk to say, okay, it now is even closer to GDPR. Yes, someone may go to jail, that's different, but all the other things seem to be slightly relaxed, more relaxed than GDPR. And so I would take this approach. It's probably going to be okay. Is that correct? Would still recommend everyone, of course, to go to a Swiss law firm. So we will.
Yeah, I mean, it's not the first time I hear the question, because we already had that under the old law, which was even more liberal than this more restrictive law. And the position was, well, let's comply with the strictest law in the territory, which is the GDPR. And if we're compliant with GDPR, then we're very likely also compliant with Swiss law. So what's the effort worth? And this is certainly true. I mean, the only thing that sometimes is a bit awkward is if companies have privacy policies in place referring to GDPR provisions and contracts only referring to GDPR provisions, or referring to the German regulator, to the Datenschutzbeauftragte, then our comment is this is not implementable in Switzerland. We need to make this a little bit Swiss.
Yeah, and just, I mean, you made sure that people will still ask Swiss lawyers by introducing criminal sanctions, because as you said at the very beginning, as soon as you say that, they want to be absolutely certain that they are not going to jail.
Yes.
So, talking about going to jail, and because you have a company, and because there is employees and employers and stuff like that, maybe we can move on to Christoph regarding the subject of data access requests from employees. And Christoph, I understand you do have slides, and if you can share that would be great, because if you all, since you all can see that I'm not really a master at sharing with Zoom.
You should see the first slide of my presentation right now, which summarizes the topic exactly. Yeah,
it works.
So I'm perfect. Within the next minutes, I'm going to talk about the data subject requests from employees in Germany. As Christian said, I usually work for the employment law department of our law firm. But more and more, GDPR also becomes relevant for employment law, because, yeah, as Christian said, employees more and more weaponize these information rights to gain a better position for settlement agreements. I have a very short agenda. I will introduce you to the legal situation in Germany versus what is actually happening. Lisa will tell you that the GDPR is in place now for 5 years, and we can see the first developments of how this GDPR is used and lived in Germany. And then I will show you the typical situation for an information request in employment law, in an employment law situation. And the last point, probably the most practical related, will be how do we deal with an information request by an employee in Germany? What's the two-step approach I wrote down here? So first, the legal situation. The GDPR gives individuals or subjects an information right, and the information right is unlimited. It basically says the controller, in our situation, the employer, shall provide a copy of the personal data undergoing processing. There isn't any limitation in the GDPR. It's just a copy of the personal data, which, as you might know, might lead to many questions as to how much does the employer have to show, and about what does the employer have to inform. There's also a time limit for this information request. The employer basically has 1 month after the request to fulfill it. And as you have surely heard, there's a very high sanction for employers if they don't comply, because GDPR says that you can be subject to a fine of up to 20 million, or even worse, up to 4% of the total worldwide annual turnover of your company. So quite some money. Additionally, and something that was completely new to the German system was, it's included in Article 82 GDPR, because we also have punitive damages. The data subject can go to court and claim damages for any breach of the GDPR. And the GDPR says itself that it shall also deter employers or processors from further infringement. So the system of punitive damages was introduced by the GDPR in Germany. And lastly, something that is also related to what Dirk said, there is a potential risk that executive bodies can go to court, because if things escalate and the employee goes to court and claims that the information he received was incomplete, normally executives are asked to provide affidavits that the information provided was complete and correct. And if they breach this obligation, if the information wasn't correct or wasn't complete, then they might go to jail. So this is something always very important for the executives, because they don't want to go to jail for something that is GDPR related. So in summary, this was the legal situation that you can see by just looking at the GDPR. The last 5 years, however, have taught us that not everything is as bad as written down in the GDPR. Most importantly, until now, it is completely unclear how much information the employer needs to provide. So far, we haven't had a binding judgment on our highest courts about what information is required. So we have very, very different court rulings that on the one hand can be very strict, and on the other hand can be very broad for the employer. For example, requiring the employee to specify what information is required and to exactly show why this information is required. Also, the time limit isn't that strict, because in the GDPR itself, you have an extension by 2 further months. And you also, as employer, have the right to refuse in case of excessive requests. I will give you an example of this excessive requests later on. As I said, the fines can get quite high for a company, but so far we haven't seen that high fines being imposed by the authorities. And most importantly, if there had been a fine, normally the authority had asked the employer first to fulfill the data subject rights. So normally the fine is just the second step after a formal warning by the authority. And the punitive damages for the employee are also rather cheap. So far, the maximum amount of damages was 10,000 euros for a delayed information by an employer, which took 20 months to answer. And the situation in court is also quite favorable for the employer, because until now, the Federal Labor Court in Germany sets very high requirements for a substantiated claim. The employee cannot just go to court and require all information processed by the employer. That would be too vague. So as you see, the situation isn't that bad as the GDPR might show. Now, what's the typical situation I, as employment lawyer, hear of an information request? In, I'd say, 99% of the cases, it's combined with a claim for unfair dismissal. So a former employee that goes to court to fight against a termination notice will almost every time include an information request based on Article 15 GDPR in his claim to the labor court. So as Christian said, it's not that much data protection related, but rather a means to get into negotiations on a settlement agreement, which the employees hope will be a means to get a higher severance payment in the end. So lastly, how do we in Germany deal with these information requests? We usually use a two-step approach. The step one, which normally settles, I'd say 80% of the cases, is just to aim for a settlement with the terminated employee, including some language on the information request. So how do we do it? First of all, we usually ask our clients to provide at least some information within the legal deadline of 1 or 3 months. Normally, we have a very standardized answer on very general processing details for the employee. And normally we ask our clients to just copy the employee's personal file and send it to the employee. As I said, in most of the cases, attorneys of employees will try to use the information request as leverage for a severance payment in court. And they always try to scare the employer with this request. But given the details I just showed you, normally we are quite relaxed when it comes to this Article 15 information requirement. So it's not that worth that much money. And hopefully, if we then come to a settlement agreement in court about the termination, about the notice of termination, we also include language on the information request. There's a slight turn because waiving the information right itself is impossible under German understanding. So we have adapted what is called in German a settlement on the facts. Both parties agree in the settlement agreement that the information provided to them was sufficient to fulfill the Article 15 information requirement. Usually, we also combine this factual statement with a waiver for the punitive damages, and we exempt any future processing. So this step one usually settles, I'd say, 80% of the cases. The 20% remaining, these are more complicated, and there we have to use, I'd say, all legal tricks available to employers. Most importantly, we usually try to request a specification. So we answer with the personal file, and we also at the same time we ask the employee, so this is the basic information, what else do you need? Why do you need the information? Please specify why you are afraid that the employer could process wrong data of you. Normally we also try to come to build up an excess case. One case we had was a former chief executive officer, and his name was included in every email of the company in the headline. So we had, I think, 800,000 emails, and to his request we answered, well, this might be excessive if we have to filter 800,000 emails checking whether your name is included just as legal information or your name is included because someone talked about you. So this is a case for an excess objection we used. And we usually try to provide additional information just as summary information. So we always try to avoid handing the employee every email that he has ever written, but instead tell him we have emails that have come to your business email account, and we have emails that you have sent while working for us. just as summary information. What is our goal with the second step? Well, we always try to come to a court settlement later on. And for the case that the employee goes to the authorities, we always try to mitigate the risk for fines by showing that the employer was good willing, that we tried to fulfill all legal obligations under the GDPR. And usually authorities know that there's still a great uncertainty of what employers need to provide, how specific they need to provide it. So we always try to mitigate the risk of fines by showing goodwill and good intent. So yes, this was a short introduction on how to handle information requests under German employment law. If you have further questions, we will circulate the presentation later on, and we also included my contact details. So I'm really happy to answer any of your questions you might have on this specific topic. Thanks.
Thank you. Thank you very much, Christoph. Is it fair to say that this is, or did you ever come across a case where there was actual concern from a privacy perspective, where the employee really had fear that his data may be wrongfully used, or that really something would come out of it that he wouldn't already know?
No,
or is
unfortunately,
it
never.
No, okay.
Never. So far, never. It's just, as you said, it's just a weapon to get a higher settlement. But so far, no fear that there was wrong data processing.
And does it work? On average, are the settlement amounts now higher than they used to be before because you always have to price that in, or is it just causing more headache within the process? Because something you don't mention, but I came across early on when this was introduced with GDPR, was that the employer spent thousands of internal hours and a lot of money on lawyers to just wrap their head around, okay, what does this mean? Do we have to give him all his emails of the last 15 years, including everything where his name is on paper or on record or whatsoever? And these are business secrets. This involves other personal information, things like that. So there was a lot of cost involved, but does it pay off as a strategy?
I'd say no. I didn't see a significant raise in the settlement sums so far. It's just, yeah, it's more work for the more work for the attorneys on both sides. Nothing more.
Okay. Ted, because again, I can't recall exactly the surroundings that we're talking about, but is that something in the US as well, with, I don't know, CCPA or something like that, or is this, or have you been spared from this?
I haven't seen it, except for in the form of just questions by clients trying to be ready and really being concerned about, as you know, many of you know, prior to January 1, 2023, employee-related data was accepted from the definition of personal information under the GDPR largely. I shouldn't say the definition of personal information. It was accepted from the applicability of the requirements of the CCPA for the most part. You still had to give a notice and things like that, but they didn't have the access rights and so forth. You know, going into January 1, everybody was, you know, very concerned, I think, and I know Jeremiah and Nancy and others from the US are on the call, and I welcome their input as well. We were hearing lots of questions from clients saying, oh my goodness, what's going to happen when, you know, we have an employee who's getting ready to leave, maybe getting ready to sue us, maybe already has left or sued us, and asks for all of their information, including the every email they've ever been on situation. How do we deal with that? So I think we were pretty well settled. They can get their employment file anyway. That's not really a CCPA issue. But what happens about all the other things that they may have been included on, copied on, sent, received, and so forth. And there was a real concern about that. So I had asked Christian if we could maybe line somebody up, and Christoph, this was very helpful. So thank you for that. And I'll, welcome any other comments from those in the US and other countries that have been worried about this same thing.
Is there anyone else on the call from a jurisdiction, or do you have similar experiences with weaponized data protection subject rights? Because it is something that is I don't want to discuss it from the standpoint of whether it's right or wrong. It's just there, and it really causes trouble for clients. So I don't know whether that was by intention or whether that is just something that hasn't been properly thought through at the beginning. But is there something like this in any of the other jurisdictions where you have similar experiences?
Hi, my name's Esco. I'm working for VLOF in Vietnam. Actually, for us, we're looking into this now because they just promulgated a new decree. This is the first overall broad sweeping regulation for data privacy in Vietnam. And it's incredibly broad at this time. There's a lot of concerns about this because the rights that were afforded to data subjects were absolute almost with no exceptions. So like the right to modify data, the right to have your data deleted. And so we're seeing a lot of fear and concern, especially from credit institutions, because if I give a loan to somebody and then they have the right to tell me to delete like 100% of any personally identifiable information, that's a really big issue, and so we're working through this right now. It comes online in about a week, and we still don't have additional guidance for it. So there's quite a lot of concern right now. In the employment context, we haven't heard too much concern yet, but I'm sure that will follow. I don't think it's, the thing is, commonly in Vietnam, what we see is a regulation comes out, and then as people have problems, they will supplement or revise or provide additional guidance. And so we anticipate that will be the same case here. But yeah, we're definitely dealing with a little bit of this. A lot of organizations are coming to us right now and asking us what's going on with this. Mm-hmm. The other thing that was really interesting about this decree that we're hearing a lot of concern about is it put in place a wholesale ban on the sale of personal information for profit, which for us, that is incredibly unusual, and it's definitely very, very strange, even because, previously there was very little regulation, and so it was basically consent-based. We could ask for consent for anything, and then after that, it was okay. Mm-hmm. And right now, as drafted, it's just a complete wholesale ban on the sale of data or personal data for profit without carve-outs. And so we're kind of looking at that, and I don't think it will stay that way, because quite frankly, that will kill a huge segment of economy. But at this time, that's what it says. The other thing that's pretty interesting about this regulation that we're kind of working through is it has compliance requirements that are extrajudicial or extra jurisdictional. So for example, they have said, hey, if there is any third-party processing of data, personal data from Vietnamese citizens abroad, those companies need to file with the Ministry of Public Security in Vietnam. And I'm really curious to see, I don't think they have the bandwidth to enforce that, quite frankly, or even process.
I don't think they even have the infrastructure in place yet.
No, definitely not. They don't, as I understand earlier when I checked this afternoon, they don't even have a portal up for submitting these they call it an impact assessment, but I don't really think that's exactly what it is. That's what they call it anyway. But Yeah, so there, I don't think the infrastructure is in place for that. So we're kind of running into this a little bit blind, but just a heads up for anybody who's has clients that are doing business with Vietnamese personal data.
Okay. Okay, sounds like there's a lot of work coming your way. And it's
Yeah, I guess so. We'll see.
yes, it's a source which keeps on giving. So we have only 5 minutes left. The idea of the last segment was just to talk about, to use this opportunity of 5 years GDPR to talk about GDPR and you know what the consequences are and what we see for the future. But it leaves very little room now for Lisa to say something, but we are actually right within that discussion already, because what you just mentioned, I don't know whether that is in any way modeled on GDPR, but still it is something that my personal view is that data protection has been ignored for so many years in maybe all across country. It always used to be complicated in Germany, and that is still this it's still what people think about when they think about data protection in Europe, and it's GDPR, blah, blah, blah. And then Germany is even more complicated, which isn't really true, but still. So we have this history, but it influenced a lot of jurisdiction and new activities all across the world. Some of it inspired or modeled on GDPR, others not. And so sorry, Lisa, for taking away your time, but maybe you can just, because you've been to another country, and we're now at someone talking about Vietnam, and go the same direction the other way across the globe to Chile, which, I don't know, what's the situation there? Has it changed over the last couple of years? Is it moving towards GDPR, or I don't know?
Yeah, it actually is. So Chile has a pretty old data protection law. It's from 1999. It was the first one in the region, the first country to have one, but since then they practically haven't moved. So there actually is a bill in the Chilean Congress which is modeled on the GDPR and pretty similar. And what I saw and what I found really interesting is that a lot of companies, and not only in Chile actually, but in the whole South American region, because we had a lot of projects within the region, is that there are a lot of companies that, even though they don't have very strict data protection laws, kind of adhere to the standard of the GDPR, because they have so many clients that require them to have a higher standard than the one required by law in their countries, that there's actually a great interest in all other countries. I at least that was my understanding. That was what I saw in the region, with complying with laws that have a higher standard. And actually, as I said, there are a lot of, not only in Chile, but a lot of countries in the region that have laws that are very similar to the GDPR. Ecuador, for example, didn't have a data protection law before, and now they have a really strict one, which in a lot of parts actually is a copy of the GDPR.
I don't know, is anyone else from the region? Not everyone has followed Hannah's requirement to change to the name. So I don't know. Is anyone else from South America online who has, you know, similar or different views? No, I can't see it.
You can't elicit a response. We do have a couple of folks on, not to call them out, but I see that we've got, gosh, I know we had someone from Alfaro from Argentina on. We've got someone from Mexico here. If any of you guys would chime in.
Just from Chile, from my side, as Lisa described, we are in the process of updating our data protection law and putting it quite in the standard of the GDPR. In practice, what had happened is that many companies, particularly if they are subsidiaries of foreign companies, they already had updated their standards. But the main change, I would say, aside from a higher standard, is that we're going to have an agency. We didn't have an agency. So even if you did not comply, an individual would have to go to court, and it was expensive. So now we're going to have an authority and higher fines. So now anybody who has not updated standards will have to do that once the law passes. It's been discussed in another, but basically going up to the GDPR standards.
Okay, so this is the European Union IT. Whenever I speak to someone from the Commission, I have a feeling that they are kind of proud that they came up with this, which is now kind of setting standards all across the globe. And I think that put them on steroids when it comes to other regulations around data that we will be looking at in the years to come, which all has to kind of fit together so that it does fit to personal data protection and the Data Act and Data Service Act and the AI Act, and which all around is all about data, and it somehow has to fit together. And that is, I'm sure, a topic which we will have to talk about in the calls to come. Now we're already 1 minute over the time, and I'm very sorry for this. If there is any question or remark or comment, I'm still happy to go for the extra couple of minutes, but if not, then I would say thank you very much for being on the call. Thank you, Dirk, thank you, Christoph, thank you, Lisa, for your contributions. And I hope to see or hear you on the next call, which will be probably in Q3, right?
Q3 or end of Q3 or Q4.
Great. So thank you all. And we will send around documents. I don't know how we do this, Hannah. We can have a chat about this, but we will. Thank you very much.
I will send around to the entire privacy and data protection group. It'll also go to the young lawyers, the recording and the presentation slides. So we'll get those out very soon.